بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على سيدنا وحبيبنا محمد وعلى آله وصحبه أجمعين. Today, brothers and sisters, viewers, everybody and anybody who's with us, and some who may be watching this later, we're going to talk about the new tenancy laws that were passed by the New South Wales Parliament. Laws, the intention of which is to make things fairer and easier for both tenants and landlords. And everyone knows, everyone who has a house, getting all these messages from the different real estate agents about property prices going up and a great time to sell. It is never a great time to sell if you only have one property, because you're going to have to pay for another property, and you're going to pay stamp duties, you're going to have a lot of expenses, moving expenses and everything else. So what people end up doing is they think they're getting a good deal, but they end up moving out and away from their friends and relatives, away from the city, away from all the amenities that they've been accustomed to. The other thing is the rental market, and rents have skyrocketed over the past couple of years, and I have to say, inexplicably, I can't find a reasonable explanation for them to go up so high, but they have gone up, and I don't accept the argument that it's migration or anything like that. I think there is something happening that we're not being told about, but today's program is not about it's not speculation about why things have gone up in price. It's more so what the new laws mean for us as consumers in New South Wales. And to have this conversation with me is financial economist and a regular guest to our conversations, our dear brother, Dr. Abulkhair Jalaluddin. Dr. Abulkhair Jalaluddin is a published author of books on economics. He has a regular column in AMUST, Australasian Muslim Times, or if I remember it correctly. You can go online, amust.org, is it .org.au, and you can see many of his articles.
Yes.
And he has a long list of achievements, mashallah. If you, before we start, Dr. Jalal, would you like to give more of an introduction to yourself, or is that enough? Have I done a good enough job today?
Assalamu alaikum, brother Keysar. I think you have done enough for today. Just what you said was, I think, for the purposes of today will be fine. Thank you.
Alhamdulillah. Okay, so the first question I would like to ask you is, what is the high-level statistics on rental and owner-occupied homes in Australia?
Yes, to understand the landscape of rental and owner-occupied homes in Australia, we need to look at the aggregate statistics we have in the past census. If we look at that, then we find that around 31% of dwellings are owned outright, means there is no mortgage on them.
35%.
About 35% of dwellings are owned with a mortgage, and 30.6% or 31%, if you like, are dwellings which are rented. These are the rental properties. So now we can say that about 1/3 of Australian residential properties are rented properties, which is a high proportion in any measure, if you like. These statistics are coming from the last census, which was in 2021, which is some years ago. But we have recent surveys based on cities and states, not the Australia-wide. from those surveys, we can say that the aggregate statistic hasn't changed much, except the rental part of it, because we know that after that census, specifically after the COVID-19 years, we had large number of migrants coming to this country. And it is highly likely that these people would be renting. That's why there are estimates that the rental properties of 31% might be up to 35% or more today. So therefore, we can safely say that the people renting in Australia, they are high compared to other countries.
Look, during COVID, the federal government was a coalition government, and that's the coalition government is always had very negative attitudes towards migration, or by always I mean in the last 20, 25 years. Um, so despite that negative attitude, and with the COVID restrictions and lockdowns, was it Australians returning home, or was it migrants who were coming to Australia to look for housing?
It was the migrants which were planned and which were budgeted. So sometimes we hear in the media that it is the labor's problem and so on, but the facts of the matter is there were, as you mentioned, there were lockdowns, and the lockdown years probably from 2019 through to 2022 and around that time. So in those years, there were planned and budgeted number of migrants, and those were done by the previous government, not the Labour government, the Liberal government. And because of the lockdown, they could not arrive. So when the economy and the aviation opened, they came. So we saw that in a yearly statistic, it was high, but actually it wasn't the result of 1 year worth of migration. It was about 3 to 4 years worth of migration, although it was planned and approved during the previous government. They arrived during the present, the re-elected Labour government. So that's why we need to be a bit careful saying that the present government or the Labour government has increased migration dramatically.
Now, I understand it's not the Labor government that increased it. In fact, what I've found over the last 25 years that Labor has been just as strict as the coalition with respect to migration intake, and um, the issue is not there. The issue is that if this is planned migration, how could they overlook the planning for accommodation? This is one of the most significant points of human movements across the globe, is that you've got to create accommodation for them. And what this has done, it's had devastating consequences on everyday Australians. If you're paying $1,000 a week rent for reasonably sized accommodation in the parts of the southwest of Sydney, you don't have much of your salary left or your wages left to buy food or to buy clothing and other life necessities. It's really forcing uh, people to more people to live together, which is not necessarily a bad thing if it keeps the family together. But uh, you're finding that people are sharing accommodation, and you're finding that they're struggling with their daily expenses. So
Yes.
yeah, so it's good that they're looking at introducing that they've introduced these tenancy laws to streamline the tenancy process and make it fairer for people, and that's something we're going to go into later. But I think government needs to do more to improve the conditions of everyday Australians, the everyday battler who can no longer afford to rent on their own. Even a family where only one per householder is working, they can't get by. They cannot pay the rent and buy food at the same time unless they're very high income earners, and that's very sad. Very sad situation for Australia. This is not Australia. This is what happens in third world countries usually. But we move on with the questions. What is the background of the recent changes in tenancy laws in New South Wales?
So now, so we are talking about the new changes in tenancy laws, and the background to that is we know that there was a New South Wales state government election in 2023, and that was held on I think 25th of March 2023. At that election, Labour Party was in opposition. So Labour Party made an election commitment to make the renting in New South Wales fairer and improve the protections for tenants. And these were necessary because of the reasons you also mentioned just now, why the rent went up and people were in difficulty and their salaries were used up in rent and things like that. So that's why they made a commitment that they will improve the protections for tenants. So when the Labour government in New South Wales won the election in 2023, they had a consultation with tenants, landlords, tenant advocacy groups, real estate agents, and industry stakeholders. And the new law we see now is the outcome of that consultation. And basically, so that is the background for these changes coming from 2023 New South Wales state election.
What are those changes? We've been talking about the new laws and the changes, but what exactly are they? What are the main recent changes in the tenancy laws in New South Wales?
Thanks for that. That is a good question. In fact, recently New South Wales government enacted the Residential Tenancies Act 2024, and all these new laws are included in that legislation. So those new laws in this new act came into effect in two tranches. One was 19th of May 2025, just last month, and another tranche was on 31st of October 2024, last year. So the main laws or the new laws came into effect on May 2025, includes abolition of no ground eviction, sorry.
Yes.
Making it easier for the tenants to keep pets in the properties, as well as ensuring that there is no fee if the tenants pay their rental payments through a bank account. Then if we look at the new laws came into being on 31st of August 2024, there were two main ones. One was limiting rental increases only one time in a year, in a 12 months period. And this applies to all types of leases. And secondly, there should not be any extra fees or expenses at the commencement of a tenancy. So these were the main topics, if you like, of the new laws. So maybe in the next conversation means the next questions we might explain further some of those laws.
Well, the next question, because you mentioned the evictions, the government estimates that there are up to 15,000 no ground evictions. So no ground means that they don't have to explain why they're evicting a person. They can just say, get out.
Yes.
And that's it. If you say why, they don't have to say why, just say get out. And this happens every year, 15,000 no ground evictions every year in this state of New South Wales. So this abolition of the no ground eviction, what does it exactly mean for tenants and landlords? If they have to provide a ground, what are the acceptable grounds for ending a tenancy in the new legislation?
Yes. So the context we have is high level of no ground evictions up to 15,000, which is a high number, telling people
Has anyone
go out.
speculated why there are these evictions? Like, is it because they want to increase the rent and they can't, or is it because
There are variety of reasons. Main ones would be like they want to increase, and the people who are currently renting, they may not be able to pay higher rent.
so it's greed?
There could be,
That's greed, that
yes,
reason. Yeah.
yeah, that could be the main ones. There are many other ones. So in that situation, this new law, what does that mean for the landlords? So for the landlords, it means that um, uh, the landlords can no longer um, evict people without a valid reason. So now these tenants could be on a periodic lease or could be a fixed term lease. So the periodic lease would be like someone has a 1-year fixed term lease. After the completion of the lease, they don't renew that. They just continue to live because there is an understanding between the landlord and the tenant that they will stay on and they will pay rentals. If they pay rental, say fortnightly, then once one fortnight rent is paid, then the renewal for the next fortnight is automatically occurs. So that is how at law it works. So if people are renting on a periodic basis, landlords cannot just tell them get out. As well as if the tenant is on a fixed term, even if at the end of the fixed term, they cannot just tell them that go out. They have to give reasons for that. On the other side, for the tenant side, it will create stability and peace of mind because they know that they cannot be evicted without a valid reason. So now, under this new legislation we have, there are acceptable grounds on which a lease can be ended. And those will include the breach of agreement. If there is a breach of agreement by the tenant, then you can be evicted. The second one would be the sale or proposed sale of the property with vacant possession. So now the properties are sometimes sold and tenant doesn't have to move out because the landlord changes, nothing else changes. But if the condition of the sale is that property will be delivered as a vacant possession, then you will get, and they have a legal right to give you a notice of eviction. The other one would be
But just on that
major.
point, Dr. Jalal, sorry to interrupt. Just on that point, that can only happen once a lease is finished, isn't it?
No, the ownership is the 100% ownership of the owner, the landlord. So landlord may decide or compelled to decide to sell the property. So if they sell the properties, then there is no utility of the property from this owner. So therefore, there will be a change. So in that change, if it is to be a vacant possession, then current landlord can give a notice of eviction because he has to sell and the property will have to be vacant. So that is on that.
Just on that point,
Yep.
if if this happens and the lease still has a year to go, for example, let's say it's a 2-year lease and it has a year to go. Is the landlord required or obligated to pay compensation to the tenant for?
Yes, those are the different processes. So if they want to terminate the lease, which is not completed yet, yes, there is a legal process on that. One of them would be the compensation paid or some other compensation on those things. So we're not going into that in depth because this is another area of law. Okay. So the next one would be the major renovations, repairs, or demolition. Obviously, then they have to give a notice for you to vacate the property. The other one would be the landlord or their immediate family moving into the property. So the law is very clear. The landlord can give a notice if they themselves are moving into, or an immediate family is moving into, not anyone. Immediate family is defined at law, which is a close family. So it's not like landlord doesn't like them, they like other people, so they just give them they are coming in, so you go out. It's not like that. The next one would be the tenants ineligibility for affordable or transitional housing. So we have sometimes a lot of them in New South Wales. In fact, we have a lot of affordable housing, which are mainly housing commission housing, and also some transitional housing. So if you lose the eligibility, then you can be given a notice to evict. For example, like someone living in a housing commission, their income has increased because they have threshold on that. So then they can be given a notice. The last one would be like the tenant is no longer a student for the accommodations which are purpose-built for students. So if you are no longer a student, then you can be given a notice to vacate. So the notice eviction or the notice period in New South Wales ranges from 60 days to 90 days. 60 days normally for the periodic leases, and 90 days for the fixed leases. Say, for example, someone is in the house for 1 year. So if you want them to go at that time with reason, then you need to give them 90 days notice so that they can find another property. So therefore, this no ground eviction was a big issue, especially around that election too. Many people were evicted for basically no reasons or the reasons for the benefit of the landlord. So this law, we think that would fix it.
Oh, that's good. That's a very good outcome for tenants. We know that well, pretty much most people, I would say, have some sort of a pet. And I know that many landlords don't like pets, and it's a condition in the rental agreement not to have pets. Do these laws impact pet ownership and being able to bring a pet into your rented accommodation?
Yes. Under this law, the tenants have strong rights to bring pets into the rental properties. So around this law, a landlord can only refuse a pet request with a proper reason. And the reasons are given in law too. It's not that the landlord can make it up. It is within the law. So those valid reasons whereby landlord can refuse a pet request would include if the property already houses 4 or more animals, obviously. If one house has 4 or more animals, then you don't be able to, bring another one. The other one would be the property is unsuitable for the type or size of the animal. Again, obviously, if it is a large animal and so on, is not suitable, so you can't
Yeah.
do that. And the next one would be it is highly likely the animal will cause damage exceeding the rental bond. So now we know that in New South Wales, we have rental bond. If you want to rent a place, so you pay a bond, and the amount is normally 4 weeks rent. So now, if you bring an animal and it is highly likely that it will cause damage, and the damage would be more than what your bond can fix. In that situation, the landlord can refuse the request. And the other one would be that the landlord resides in the property. If the landlord residing in the property and renting out one room or something like that, subletting or whatever it is, then it can be refused. The other one would be keeping an animal would breach other laws or strata laws. So there could be strata rules that prohibits animals in the premises. In those situations, you could be denied to bring a pet. The last one would be the tenant has not agreed to reasonable conditions for keeping the pet. So now if you bring a pet, there could be that the landlord is imposing some conditions whereby the property will be kept properly and things like that. So if it is reasonable and the tenant is not complying to that request, then landlord can refuse the request. So without these specific reasons, landlord under this law cannot just come and refuse a request to bring a pet.
Um, Now, I know you
Yep.
mentioned this, but just to emphasize for the viewers, and the listeners, where this is going to be broadcast on Voice of Islam Radio soon, inshallah. Are the landlords allowed to charge additional fees for bank transfer of rental payments under the new law in New South Wales?
No, landlords or the agents cannot charge a fee just because people are paying through their bank accounts. So what happened was before, In some cases, not all the cases, landlords or the agents will charge a fee because they will say, oh, we have to keep the accounts and things like that. So you pay a fee for that. So the law prohibits that. And the reason behind that is, you see, if I'm a tenant and I'm paying the rent, so I'm paying from my accounts. So account keeping fees or any other cost of that account is borne by me, not the real estate or the landlord. So there is no reason for them to charge a fee on that. So this law definitely, specifically from 19th May 2025, it is prohibited to charge such fees.
Yeah, well, that type of fee is very unreasonable. How do you expect them to pay? Isn't there an accounting requirement also if they bring cash or if they give check? It all requires matching the payment to the account of the tenant. So it just seems that maybe those fees were there to perhaps to get cash and not pay tax on it. Allahu alam. But it's so good that they got rid of this unfair and really unconscionable fee that they were charging the poor tenants.
Yes, I fully agree on that. Yep.
Yeah. Now, how often can rent be increased under the new laws? I know you mentioned that, but I want to emphasize this again for the viewers and listeners.
Yep. So now, under this law, landlord can increase rents only one time in a 12 months period. So another thing to emphasize on this, and this rule for increase of rent is for all type of lease. So now the lease could be a periodic lease. Lease could be a fixed term lease. Lease could be a long-term lease. The lease could be a caravan park lease. So all sorts of lease, including the commercial lease, because mainly we are talking about the residential, because the law we are talking about is the Residential Act. But law, this particular act encompasses even the commercial properties and different types of law, different types of leases. You cannot increase lease more than one time. So what happened was in the past, sometimes people had 6 months lease. So at the end of the 6 months, they put the prices up. And there was a shortage of rental properties and people were in hardship to find a property. So those are the things is being prevented with these rules. Whatever is the lease term, could be 3 months. You can go and have a 3 months lease. Even if lease finishes, you cannot increase it. You can only increase within a 12 months period. Having said that, there is an exception to the rule. The exception is for social housing, like this government housing and also the housing commission and so on. And the rule is if they get a rent rebate from the government, then the rent can be changed more than one time in a year. That is because the rental rebate is coming from the government. So if government pays you more, and you are renting at a subsistence level, then the landlord, whosoever it is, it could be a government landlord, they can ask the tenant to adjust the rental payment because you are getting more money for rent, for the purposes of rent, and you are renting at a below market rate. So that is the exception we have in the law.
And is this impacted by CPI increases? Let's say the normal market rental value of the property has not increased, but the government gave you an additional subsidy. The fact that the normal market rent has not increased, and I know it's unlikely for the government to give you if the rent hasn't increased, but let's say theoretically that you got this additional subsidy, but the rents are still the same. Can the landlord still raise the rent or ask that amount that we
Is a
discussed?
good question. Generally speaking, these subsidies or rebates, they are not indexed, so nothing to do with the inflation rates. So it comes, government says this percentage or that percentage will give you as a rebate, so you use it for that. So it's not indexed.
The next question is also a recap question because I know you mentioned this during one of the earlier questions or discussion points. Uh, can the land does the new law allow additional fees at the commencement of a lease?
No. And what it means is the landlords, they cannot just charge or just introduce different types of fees when people enter into a rental property. It could be mainly in two ways, if you like. So when people want to come and rent a property, then there is a background check. Also, there is a credit check. So sometimes the landlord or the real estate agent says that we are going to charge a fee before you enter the property.
Yeah.
Sometimes it is not guaranteed that you will be given the property, but they will charge because we do this work. So now, if we look at the function of the landlord as well as their agents, real estate agents, we find that economically speaking, this is a function of the landlord or their agents. So there is no reason why you are charging for your job to do another person. So
Yes.
it is prohibited. Another one is sometimes you need to prepare a rental agreement, and some of the rental agreements could be very, very complex. Sometimes they would need participation of a lawyer. Even then, in those situations, landlord or the agents cannot charge a fee for that purpose because of the same reason as I described before, because this is a function of the landlord to do that. If they want to protect their property from any risk emanating from the tenants, then they have to do that. And the background to that is in the years leading to just after COVID-19, in the marketplace, these two types of fees were rampant. The landlords and the agents were coming and just imposing this type of extra fees before even the tenancy commences. And this law hopefully these laws will fix this
Inshallah.
situation.
My next question is about the landlord register. What is the landlord register? How will this help tenants? Will it help tenants? If so, how? And is there any experience of this register in other states and
Thanks for
how was effective?
Yep, thanks for that. This is a good question and is a good reform if it is done. The landlord register is just a register whereby the incidences related to the landlord is recorded for public purposes. Public can see this. So in New South Wales, we do not have a landlord register whereby it is publicly identified and recorded the history of landlords with misconduct, for example. And this misconduct is, in fact, is a defined concept. Misconduct will be a breach to the law. In this case, if a landlord breaches a rule under the Residential Tenancies Act 2024, then that breach will be recorded in this register. So because we don't have this, many advocates who advocate for tenants mainly, they're saying that we should have one because it will increase transparency in the marketplace. It will deter poor practices by landlords, and it will improve decision-making processes by the tenants because they will know, okay, I'm going into this property and this is the landlord, and they have these convictions recorded publicly, and they breach those laws in relation to tenancy. So that will make them to go for informed decision making, if you like. So now, only states in Australia that has this register is Victoria. So Victoria has this, and it was established in, I think, it was March 2021, some years ago. But the issue is, until now, they have around 16 or so, or some counts this and 18 entries in this database. So that will raise a lot of questions. One thing could be that it is underreported, or it could be that there are challenges in enforcing this law in Victoria. So if we are going to have one in New South Wales, the government will have to look into those matters so that it can really reflect what is happening in the marketplace. Surely, from 2001 through to 2025, there would be more than 16 or 18 breaches. So those needs to be taken care of when if and when the government wants to commit to this reform.
Final question, concluding question, and you've been generous with your time today. Thank you very much. We've already been going for almost 3/4 of an hour, so thank you for giving our viewers this time. I know you work hard all day and you come home and this is family time, but inshallah this will be of benefit to everybody. The concluding remarks or views, how do you think that these changes will improve life for renters in New South Wales?
Briefly, in my view, it will improve the life of tenants because of all the things we discussed. I don't want to repeat all that. All the new laws we have that will provide more certainty to the tenants, and it will improve the protections for the tenants' rights. Specifically, if the suggested reform of establishing a landlord register is implemented, I think that will also improve the transparency and also the decision making by the tenants in the marketplace.
Well, Jazakumullah khairan. May Allah bless you and reward you and enable you to help our community and our viewers with more issues and Thank you very much for all the hard work, for writing about these issues, and for also speaking with us about these issues. And if anybody has any questions, as usual, send them to me or directly to Dr. Jalal, and we will give you anything that hasn't been covered today. If you send it to me, I'll pass it on, and we'll give you an answer, inshallah. So again, thank you very much. Wassalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum assalam wa rahmatullahi wa barakatuh.